Hello, all, how are you? Today, let us begin a new topic Companies Act. What is a company? What is its meaning, definition, and characteristics? It is going to be very interesting. Stay tuned. So, company in common usage it refers to voluntary association of individuals for attaining some common social purpose. But strictly, company has no technical meaning. But nowadays, in the company has got legal meaning. But what is a company? Company is an artificial or legal person created and devised by the laws for a variety of purposes such as promotion of charity, art, research, religion, commerce, or business. So let us get into the definition. Yale Law Journal has defined company as a company is an intricate centralized economic administrative structure run by professional managers who hire capital from the investors. So another definition from Companies Act 2013 as per section 2 clause 20 says that company means a company incorporated on this under this act or under any previous company law. So as such company don't have any particular definition. Lindley has given a particular definition. A company is an association of many persons who contribute money or money's worth to a common stock and employ it in some trade or business and share the profit or loss arising therefrom. So, as such, we don't have any particular meaning for company. Lindley's definition also gives some idea what a company is. Like we have a gathering of few persons, they contribute money or some money is worth, and they involve in some trade or business and they share the profit and loss. So coming to characteristics of a company, what are the characteristics of a company which make the company so special? 1. Voluntary association. A company, as such, we have read in the definitions, it is an association of individuals formed for some purpose, but it is a voluntary association of purpose and the capital is divisible into shares, and at the same time, the artificial person, it is an artificial person which is created by the law. Second is the separate legal entity. A company is in law regarded as an entity separate from its members. In other words, an independent corporate existence. Any of its members can enter into contracts with it in the same manner as any other individual can. And the persons cannot be held liable for the acts of the company even if they hold virtually the entire share capital. The company's money and property belong to the company and not to the shareholders. Once a company is incorporated, it must be treated like any other independent person, and the motives of those who promoted it are irrelevant. In England, an incorporated company's legal personality or a separate legal entity was recognized in 1867 in Oakes versus Turquoise case. So, we have a certain many number of case laws which prove that company has separate legal entity. The very important case law, Salmon versus Salmon and Company Limited. Here, Salmon was a boot and shoe manufacturer. He formed Salmon and Company Limited. And later, the share capital of that company is £30,000, and he took 23,000 shares for £1 each. £1 each share. And his wife, one daughter, and 4 sons also took shares in that company for £1 each. And he also have the debentures of £10,000. The debentures gave Salmon a charge over the assets of the company as a consideration for the transfer of the business. So one day the company wound up. So its assets were found to be £6,000 and its liability amounted to £17,000, of which £10,000 were due to Salmon and £7,000 due to unsecured creditors. The unsecured creditors, what they said is Salmon and the company were one and the same, and that the company is just a mere agent for Salmon. So the unsecured creditors should be paid in priority first. But in reality, company is a separate legal entity. What did the verdict came is, the company in the eyes of law is a separate person independent from Salmon, and it is not an agent. Salmon, though virtually he is holding 23,000 shares in the company, but he was a secured creditor, and the priority goes to the security creditor and not to the unsecured creditor when winding up a company. After this case law, some principles have been taken out by Judge McNaughton. He said that company is at law a different person altogether from the subscribers to the memorandum, and though it may be that After incorporation, the business is precisely the same as it was before, and the same persons are managers and the same hands receive the profits. The company is not in the law of the agent of the subscribers or trustee for them, nor are the subscribers liable in any shape or form except to the extent in the manner provided by the Act. It simply says that company is independent even though the same subscribers, the same managers, the same hands receive the profits, but still the company is having separate legal entity. A company in the eyes of law is a person distinct from the individuals who are its members. It owns its own property. It owns its own debts. It can sue and can be sued on its own name. It has its own independent corporative existence, and it has known its corporate personality. So, the own corporate personality has made it as a legal person involving its own identity. In another case, law of Lee versus Lee Farming Company. Here, the Mr. Lee was a pilot. He formed Lee's Air Farming Limited. And out of 3000 shares, and he only took 2999 shares, and he was the managing director of the company. He himself voted for the appointment of pilot in the company, and thus he was appointed as a pilot. But after a few years, he was killed in an airplane accident. So what happened? Mrs. Lee claimed the compensation from Lee's Air Farming Limited and its insurers. The insurers contended that Mr. Lee was not an employee of Lee's Air Farming Limited because he himself retained the shares of 2999 out of 3000 and the company, and he was the same person. But the judgment came that the House of Lords gave the judgment in favor of Mrs. Lee. Their lordship held that the company Lee Air Farming Limited has separate legal entity and it was independent, and the magic of corporate personality enabled Lee to be the master and the servant at the same time. So, in this way, Mrs. Lee got the insurance from the insurance company, even though if a person holds almost all the shares of the company, but still the company has its own legal existence, it has its own independent corporate personality. Another case of Condoli Tea Company Limited. In this, some persons holded certain estate. So they formed Condoli Tea Company Limited and they themselves became as a members of that company. They wanted to transfer those estates to the company. According to the law, when the immobile property is transferred from one person to another person, stamp duty has been paid. That is a common thing. So the government issued notice for the collection of stamp duty from the shareholders. They contended that they said that they are transferring their own property to their own company. Why do they need to do the stamp duty? Then again the Privy Council said that company has its own legal entity, and the property, debts, etc. from its members is independent. When the company was purchasing certain properties of its own, it must pay stamp duty. Another case of Abdul Haq versus Dasmal. Here, an employee who has not been paid salary for several months sued the director for the recovery of salary due to him. But director cannot be sued because the remedy lies against the company and not against the directors or members of the company. He had to sue the case against the company. In the another case of Ramachandran versus State of Kerala also, here if for any dues or arrears in the sales, anything, company has to be sued because company has separate legal entities and not the directors and other managers of the company. In Indian Oil Corporation Limited versus Chief Inspector of Factories also, the Indian Oil Corporation is a registered company under Companies Act 1956 and it is completely owned by the Government of India under the Section 617 of Companies Act. But this company has breached some of its provisions of the Factories Act 1948 in some of its factories. The Chief Inspector of Factories and Labour Commissioner, when he inspected the factory, he noticed several violations. Then he gave a notice to the Board of Directors of Indian Oil Corporation. So it contended that we were established by the Government of India and it was a part of the state and provisions of the Factories Act, and so you cannot give any notices to us. But the Supreme Court gave judgment against the Indian Oil Corporation and said that it may be a registered company and it is a person having separate legal entity and separate from independent existence, and it has its independent existence. You can't blame the government for this charges. So when the Indian Oil Corporation has violated some rules, then Indian Oil Corporation should only has to pay for the charges. Important characteristics is limited liability. The privilege of limited liability of business deed is one of the principal advantages of doing business under the corporate form of business organization. A company may be a company by, there are two types of companies, company limited by shares and company limited by guarantee. So in company limited by shares, the liability of members is limited to the unpaid value of the shares. For example, if the share value of the company is 10 rupees and the member has already paid 7 rupees, so he is due only up to 3 rupees only during the lifetime of the company. But in the case of company limited by guarantee, the liability of the members is limited to such amount as the members may undertake to contribute the assets of the company when it is being wound up. So in the case of Jakin versus Pharmaceutical Society of Britain, what happened is limited companies are offsprings of a proved necessity that it is the men should be entitled to engage in a commercial pursuit without involving the whole of their fortune in that particular pursuit in which they are engaged. Another important characteristic is perpetual succession. We know that company is a juristic person, it is having perpetual succession. It is not susceptible to the 1,000 natural shocks that flesh is heir to. What a beautiful meaning. Even if somebody dies, company will not close. So, as such, it never dies. Nor it does its life depend on the life of its members. It is not in any manner affected by insolvency, mental disorder, or retirement of any of its members. It is created by the process of law and should be put to end by the process of law. Members may come and go, but the company can go on forever. It is continues to exist even if all of its members are dead. Even during the war, all members of a private company, while in general meeting, were killed by a bomb. The company survived. Not even a hydrogen bomb could have destroyed it. So it's simple and clear that even though the persons, the managers who are working are dead also, the company will exist. So that is the meaning of perpetual succession. Perpetual succession therefore means that company's existence persists irrespective of the change in the composition of the membership, and thus it is continued to existence and is not affected by the constant change of its memberships. And it is like the river Thames. It is the same river, though the parts of its composite are changing every instant. And as the river is a running stream of water known by certain name, so the company is a running stream of fiction composed of certain number of members, which may be constantly changing, but company like a river remains unaffected. The another important characteristic, common seal. Since the company has no physical existence, it must act through its agents, and all such contracts entered into by its agents must be under the seal of the company. The common seal acts as an official signature of the company. Transferability of shares. The capital of a company is divided into parts called shares, and these shares are subject to certain conditions, and they are freely transferable, so that no shareholder is permanently or necessarily wedded to a company. When the joint stock companies were established, the great object was that the shares should be capable of being easily transferred. Coming to separate property, as a company is a legal person distinct from its members, it is capable of owning, enjoying, and disposing the property on its name. Although its capital and assets are contributed by its shareholders, they are not private, and they are the joint owners of its property, and which is controlled and managed and disposed of. It is observed that no member can claim to be the owner of the company's property during its existence or nor during winding up. The shareholder doesn't have any insurable interest in the property. The same case we can see with the case law here in Macura versus Northern Assurance Company. Here there was a timber merchant who owned timber business. He formed Northern Assurance Company Limited and became the managing director. The timber yard was transferred to the company. He insured entire timber yard on his personal name. Later the timber yard was destroyed in a fire accident. And he claimed the insurance. So when he claimed for the insurance company contended that the timber yard was owned by the company and insured by another person. Therefore, it cannot be paid any compensation to it. And the House of Lords also, they said that insurance company was not liable to the timber merchant because he did not register under the name of the company. He registered under his own name. Capacity to sue and can be sued. A company can sue and to be sued in its own corporate name. It may be inflict or suffer wrongs. It can in fact do or have not done it. Most of the things which may be done by a human being, but still it can sue and it can be sued. As such, we have come to the end of the session. It's riddle time. Please answer the riddle in the comment section. Please like, share, and subscribe. Thank you.